Good morning. We are about to start this first session of the second day of the Quaestio Facti workshop. I have the pleasure to introduce Professor Paul Roberts. Indeed, he needs no presentation because he is a very well-known author in proof and criminal evidence. Today, he is going to talk us about the so-called legal truth.
Well, thank you very much. I'm delighted to be here. Thanks so much for the invitation. You're looking after us so nicely, as you always do. And as John and others mentioned yesterday, I'm very excited about the journal, the great ambition. It's certainly ambitious. The multilingual and the comparative dimension of that, I think, is going to be challenging, but I think, rewarding as well. And already we started yesterday with some discussion about the methodological challenges and difficulties of doing comparative scholarship, comparative research in these areas that we're all interested in: evidence and proof and fact-finding, law of evidence, criminal procedure, civil procedure, and so on. So it's all a very positive start. My topic today is legal truth, or so-called legal truth, and perhaps if you've read my short summary and motivation for the paper, which I circulated in advance, you'll see where perhaps the so-called comes from. Indeed, when I've given a previous iteration of this paper, it was called Against Legal Truth. So again, that's probably a clue as to where we're going to be going with this material today. Just final prefatory remark, really, and I want to say this. This is still work in progress, really. I'm still really thinking about these issues, and I wanted to flag that right at the beginning, because the more I go into this, the more dogmatic I will become as a matter of presentational style. But I just want to say right at the beginning that I'm still persuadable on these topics, and very much welcome your input and discussion. So even if I sound dogmatic, I'm not really. So, now, what did we say? That way, was it?
No, right, left and right.
Left and right.
Okay.
So, let's start. So, the problem with truth. I want to start with some recognition of the problem with truth from popular fiction, and you might get a clue as to my recent reading. So, this is from Jonathan Strange and Mr. Norrell. Yes, indeed, agreed, Mr. Norrell. I should dearly love to know the truth of the matter. Ah, yes, well, Lascelles gave a short, contemptuous laugh. Truth. Colin Bateman, another interesting observation. Says, I don't know if you know this. John, do you know Colin Bateman's novels?
Oh, yes.
The Northern Irish Connection. This is from not the Prisoner of Zenda, but the Prisoner of Brenda. And it's his Mystery Man series of novels. The protagonist says, it always starts like this, with something small and uncomplicated, but pretty soon there are bodies all over the place and I get beaten up. Does Alison know you're pursuing this? Up to a point, I said. Jeff blew air out of his cheeks. I only ever wanted to be a poet, he said. Not to be involved in murder and mayhem. You choose to work in the book business, Jeff, I said. Murder and mayhem go with the territory. He nodded, because he knew it was the truth. So I just wanted to leave that I'll come back to some of these ideas. I'm going to leave that hanging there in the air for now and go on to something a bit more serious. The South African Truth and Reconciliation Commission from several decades ago. Some of you may know this material. One of the things that the South African TRC had to do when it was set up as a Truth Commission was to think about what it meant to find the truth. And a very famous statement it made close to the beginning of its report. But what about truth and whose truth, it said? The complexity of this concept has emerged in the debates before the Commission. It says, resulting in 4 notions of truth: factual or forensic truth, personal or narrative truth, social or dialogue truth, and healing and restorative truth. Goes on to talk about intervention of Archbishop Desmond Tutu, talks about that, and he says, by telling their stories, both victims and perpetrators gave meaning to the multi-layered experiences of the South African story. These personal truths were communicated to the broader public by the media. Personal truths. So, let's move on more directly to law. Some of these names might be familiar to you. Elizabeth Loftus is a very famous psychologist who does research on things like eyewitness testimony. In an article some years ago, she writes with Paul Camper, the concept of truth must not be viewed as something that is absolute. Rather, truth must be defined in relation to the ends which it is intended to serve. In the fields of law and psychology, both the ends and, crucially they say, and therefore the concepts of truth differ. Concepts of truth differ. And then much more recently, the legal scholar Herrnstein says, legal use often does not fully correspond to the meaning the same term has in natural language nor in other contexts. Okay, so far so good. First proposition is there can be legal terms of art, and those legal terms of art may not fully reflect or faithfully track the meaning of those words in ordinary language. I think that must be right. So far so good. There can be what we call legal terms of art. It goes on to say, similarly, the concept of, and now we see the scare quotes, legal truth, which is a function of the rules of evidence, differs from other conceptions of truth. Concept of legal truth differs from other conceptions of truth. So these really are just examples, illustrations of something that I hear people say all the time in one way or another. They say it in professional discourse, legal scholars say it, and they say it in popular discourse as well, or in things that are intended to address the general public from an official capacity like the South African TRC. And these kind of statements got me thinking, is that right? Are there really other conceptions of truth? That's the kind of question, really. What about this so-called legal truth, then? Well, I started to look into this, and the very first thing that I noticed was that clearly people were using the concept in a different way and to mean different things. So it seems the first task when we investigate this idea is to try and disambiguate, to try and interpret, to try and make sense of the different uses that the concept might have. And in my reading, I can see at least 5 different versions of legal truth. 5 different versions attempt to make different kinds of claim. And I've labelled these claims, although I keep changing the labels. I'm not totally happy with all of the labels. But the labels I've got at the moment are the following 5. First of all, it could be something to do with the nature of propositions of law, and I've called this the ontological claim. Ontological claims about the nature of law. Secondly, there could be a conceptual claim about the nature of legal rulings and their performative significance. One idea of this is res judicata, but that doesn't cover all of it by any means. We'll come on to that in a moment. So, second meaning then, conceptual claims about legal truth. This leads on, thirdly, to what I'm calling theoretical, or more specifically, critical epistemologies. Fourth, this may be the least satisfactory label right now. I've changed this a number of times, but at the moment, I'm calling the label for the 4th type of claim procedural methodology, and this is to do with ideas about success and failure, and again I'll explain that. And then finally, Another type of claim that is being made relates to what we can describe as the normative priority of ideals of criminal justice over epistemic endeavours. So the thought here is that criminal adjudication is first and foremost an aspiration of political morality, and that epistemology serves justice and not the other way around. Right, so most of the rest of what I've got to say in the paper, and what I'll say today, are examples of each of these five, and elucidations. I hope you'll see from the examples what I mean by the labels. As I say, the labels might not be perfect. So, firstly, ontological claims about law, which is really an endeavour in analytical jurisprudence. And the first thing I would say about this usage is I was surprised by this. I didn't expect to see this kind of usage around legal truth. My second thought was that it was irrelevant to anything that I'm interested in. But then my third thought was that was a mistake, and actually it might be relevant after all. But let me give you some examples. So here's a philosopher, Alan Goleman, talking about the force of precedent. Notice published in a philosophy journal, not a law journal, just point that out. And so he says, a correct legal argument from precedent conclusively determines the law that governs the case at hand. Such an argument conclusively establishes the truth of the proposition of the form. It is the law that. How can this be when the appeal is only to analogies and not to universal hypothetical premises? The answer would seem to lie in the nature of legal truth. Okay, there's the usage, the nature of legal truth. According to Goleman, the nature of legal truth is to do with, I would say, the validity of propositions about law. There's an old friend of mine, Brian Bix, who some of you might know about. He's quite a well-known American legal philosopher, jurisprudent, writing much more recently in Oxford Journal of Legal Studies. Again, making this same point. Truth in legal propositions, and then here's it. At times, the law simply is what official collective state is. Legal truth, like truth regarding the meaning of conventional terms and language, is a function of collective judgments, and so on. So again, you see, he's using this idea of legal truth to mean something to do with the ontology of law. Propositional claims about legal validity. And I rather like this quotation as well, from a scholar that I don't know, but writing in an American journal, you see. He says, legal truth is a highly equivocal term. So far, I think that's a good start. I agree with him, it is highly equivocal. And then he says, it could refer to the metaphysical truth of propositions thought to lie on the law side of the law-fact dichotomy. Or he says, a proposition is legally true in the other sense, when it's justified in light of whatever method one has for justifying legal claims. And then he says, when I refer to legal truths, I mean propositions that are justified by reference to the law's internally prescribed epistemological standards for deciding what the law is. So what I like about this quotation is, he starts off by saying, well, this term legal truth is equivocal and it's unclear what it means. And then he says, it could mean one of two things. But both of the two things that he thinks it might mean are something to do with the nature of propositions of law. It never even occurs to him to say, well, it's got something to do with fact-finding or procedure or anything like that. I think it's very interesting that people who do analytical jurisprudence have used this term and dealt with it, but they seem to be talking about something completely different to, I'll say, us. Okay, what about the kind of... So that's the first usage. The second usage is the conceptual claims. And it seems to me that this has related some ideas of legal formalism. So, a scholar writing in the Canadian Law Journal, quite recently, she says there's a distinction between legal truth and factual truth. Factual truth refers to what might be described as historical truth. Legal truth, she says, refers to an assessment of the evidence against a legal standard of proof. the reason I describe this as conceptual is it doesn't seem to me necessarily to be making any kind of epistemological claims about the nature of legal truth. It simply seems to define it as whatever is found in accordance with legal standards of procedure and fact-finding is the legal truth. So that's why I'm calling this a conceptual claim or a formalistic one. So, a slightly different take on this idea from Teubner. He wants now to talk about epistemic authority. This epistemic authority of legal discourse is an undeniable fact of modernity. And we've found means to cope with the fact of, Teubner says, multiple truths. Scientific truth, legal truth, political truth. I haven't counted all these up, but if someone can keep count of the number of truths, that's at least 10 so far, I think. If you add narrative truth and historical truth. Even if it can be proven with scientific evidence that a factual statement in a legal procedure is blatantly wrong, that factual statement of the court, and even worse, its legal and economic and social consequences, will not be reversed. This is what I would call, he says, the epistemic trap of modern law. Law is forced to produce an autonomous legal reality, can at the same time immunise itself against conflicting realities produced by other discourses in society. So, I anticipate, I hope that this kind of claim will be familiar to some, if not all of you. Teubner's working in a structuralist, autopoetic kind of theoretical frame, according to which certain institutional discursive formations produce their own language and their own validity claims, and in a sense they can only be interpreted internal to that discourse, to that institutional formation. But Teubner's point is there are lots of competing normative formations in society. So the law might say one thing, but the media might say something else, and politicians might say something else. And so you have these competing discourses. And then the epistemic trap, according to him, is law has to somehow deal with these external claims, but is committed to its own claims internally. Something like that. So you see, again, this seems to me a kind of conceptual claim about the nature of law and its epistemic authority. One of the things I'm interested in, and I know at least some of you are also interested in this, and perhaps everyone is, concerns the relationship between law and scientific or expert evidence. And that's one very practical way, and of course we heard about this yesterday as well. That's one very practical way in that, if you like, these discourses might be thought to collide. This is where they come into contact with one another through the medium of expert evidence. Well, in the context of legal truth, we also find expert witnesses and people from other disciplines related to expert witness testimony talking about legal truth as well. So here's a psychiatrist's perspective on the issues. Therapists often say that narrative truth is of greater importance than historical truth in working with troubled individuals. If the therapist's search for narrative truth is displaced by the law's search for historical truth, the practical result of litigation is legal truth. Again, so you see the conceptual idea. Law produces this by the fact of the way that it behaves as law. That is what a judge or jury finds to be the facts of the case. Now, again, this is a development of Teubner's idea, but at a more micro level. But he says, the parties generally adhere to their version of truth, regardless of the verdict. And the only sure thing about legal process is it establishes with finality the legal system's determination of the facts. Thus, between the accuser and the accused, who may still disagree on what the truth is, only the legal battle is over. But the debate about the truth continues. And you'll notice that in this extract, truth is now appearing in the scare quotes and everything. So I just say as a footnote, as soon as you see that happening, this is an indication that something's already going wrong in the analysis, where people just won't say truth, they have to say truth. And here's a much more direct account from someone who is an expert witness in the US. He says, I don't find presenting diagnoses useful. That's, the thing that I normally do in my medical job. I don't present that in court. It says, I think they confuse lawyers for legal purposes. Diagnoses do not convey legal truth. Legal truth and scientific truth may have nothing to do with each other. So what's happening with this sequence of quotations now is it's making the same point in a way, but becoming increasingly sceptical about whether there could be any truth to truth claims. It's all now in quotes. And at this point we see one truth, another truth, may have nothing to do with one another. Now, there are different ways that you can go with this thought, right? And I'll draw some of those out. This is one version of which I have some sympathy with. This version encourages us to take seriously the idea that evidence and proof in adjudication are constructed through the process. So some version of institutional or social construction of facts. As I say, and I'll say more about this in discussion, but I have some sympathy with this version. So, I think this person's actually an anthropologist, but she says, it's important to view legal truth as something that is constructed rather than uncovered. Although in the Anglo-American legal tradition, prosecution is deemed a means of applying the legal rules to facts, not to structural falsehoods. The facts that police collect and the judges and juries consider socially constructed, and the rules are defined in part through their application. Legal facts do not exist as such until they are created or constructed by the legal process. Once rendered authoritative, legal truth shapes material reality. Even after being rendered authoritative, however, legal truth is still contestable, as there are multiple ways in which people can respond to particular legal outcomes. Now, as I say, I wouldn't necessarily have written that passage in exactly that way myself, but I have considerable sympathy with that view, and we can come back to this, but I also recognise that that kind of statement is often misinterpreted and misunderstood. Anyway, we'll come back to that. The other way of interpreting this kind of thought takes us to my third account, which I'm not going to spend very long on, and this is the much more directly sceptical epistemological position, once you've got to truth and different truths and so on. So here's an article, you see, it's how the criminal justice system knows, and although I think, when I've spoken to him afterwards, Andrew Green would deny this interpretation, I think if you read the article, this is what it seems to say, and it looks like, to me, a very crude version of truth is a function of power. Truth exists when the powerful say it does. Criminal justice agents invariably claim that through investigation and rigorous legal process they reveal the truth by making facts known. Truth is revealed by experts using power. Criminal justice system knowledge is the knowledge constructed through the exercise of power by its agents, and it is privileged and made effective by the criminal process. This knowledge does not hide its association with power, but displays it because it depends on it. The legal truth is just the truth of power. And this is, I think it's a very Orwellian thought, I think. You know, if Big Brother can make you see six fingers, then there are six fingers. So this is Donald Nicholson. Again, I don't know if you know Donald. Evans scholar, sometimes writes about epistemology. This article is a revisiting of something that he'd written previously in the Modern Law Review. At some point, I will reply to this article along the lines of saying, not taking it seriously enough. I think I'm going to call my article, Taking Epistemology Really Seriously. I think Donald doesn't do that in this article. I think what he does is get sucked into a very boring pre-Socratic debate about scepticism, to which Plato and Aristotle knew all the answers, all the good answers, and that debate, in my view, hasn't really moved on for the last 2,500 years. So, but anyway, he ends up saying things, I mean, I agree with some of what he says in the article, but he ends up saying some things that sound very much like what Andrew Green has just been quoted as saying. By seeking absolute and objective foundations to knowledge, traditional, especially Enlightenment epistemology, is an exercise in legitimation of the status quo. This is this power claim again. By purporting to be able to discover the universal grounds that distinguish opinion from knowledge, belief from truth, fact from value, to provide the universalistic and objective foundation of knowledge and truth claims, knowledge appears to be cleansed of perspective, politics and power. That's different to Andrew Green. Andrew Green said power makes itself obvious. Donald's going for a more kind of Marxian false consciousness ideology kind of claim. And then he says something that really caught my eye, I'll put it that way. Skeptics deny, he's with skeptics, skeptics deny there exists some objective truth which enables knowledge to be distinguished from mere belief. Well, if there are no criteria to distinguish knowledge from mere belief, epistemologists are wasting their time. They're in trouble. But I'll leave that thought with you, because I don't want to dwell on this third usage. I think it's the most mistaken. I think it's full of errors. I think it's misleading. I think it misses the point. So I won't say any more about that. But certainly some people who use this term, legal truth, mean to advance sceptical theses, sceptical epistemological theses. Right, so we've got 4 and 5 left now, and these to me are the more interesting ones. This is, I think, where the business really starts. You remember I said that I called the 4th one procedural methodology, but I'm not necessarily crazy about that title. So I'll say right away that when I originally sketched this out, it was procedural methodology failure. But when I investigated the matter further, it was interesting to see that some people wanted to make success claims. So we'll start with those and then move on to the failures. So here's one version of the success claim, which I think is not popular now. This is very much a kind of like a historical account of a particular kind of late 19th century, early 20th century legal pragmatism. But it does make strong claims for the outcomes in a way that what I've called conceptualist account doesn't. So this is somebody talking about Oliver Wendell Holmes, and basically saying that there's something special about the legal method, inductive, analogical, you could say casuistic, although casuistry has a bad reputation in European thought. But I think that's, case-based reasoning is kind of what it is. And a claim can be made about the success of that kind of reasoning. So this is a legal historian talking about the common sense of law. And it says, far from claiming that judges do or must deploy abstract principles, some of these commentators, including Holmes, insisted that legal science entailed the discovery of moral and legal truth, through the process of deciding concrete cases. So this is a big claim for the success of the legal method. And interestingly, the claim cuts across the substantive procedural distinction as well, I think. It's truths about law, but also truths about the application of law. It's quite an interesting claim. Now, you might think that's anachronistic and that nobody believes stuff like that anymore. But I don't know if you know this book by Bob Burns, A Theory of the Truth. So a theory of the truth is what happens when a procedural scholar who is interested in both Aristotle and Wittgenstein This is what happens when you put all those ingredients together. This is a version of the trial according to somebody who knows the practical detail of criminal adjudication. He's an American writing in the US. Inflected by both Aristotle and Wittgenstein. Burns's account is to do with the special political and moral significance of the type of adjudication that exists in the United States, particularly thinking about jury trials and criminal proceedings. He wants to say that this is a unique occasion in which something is done. It's a kind of magic, a kind of alchemy that makes it true in a much deeper sense than any logical syllogism or any formal proof could demonstrate. And I have to put my hand up and say that I have some sympathy with this view, even though to many people it sounds irrationalist. He wants to say that the moment of the trial, the particular case, is literally unique. It's a unique moment where, if the process is followed in the right kind of way, it creates a very special, deep truth. And that truth is always about, I'm running ahead a little bit here, but that truth is always about the criminal responsibility and liability of this individual. And that's never, as it were, just a question of fact. And I'll come back to that. So this is a strongly, I say, normativized conception of what fact-finding in criminal adjudication entails. I won't say too much more. I could go on. But the quote is this. The reach of second convictions is always indeterminate, and in law, extension is definition. You know, you can apply this it's a very good thought, this, I think. You can apply this very directly to some of the debates we were having yesterday. You know, lots of people want to say, what does it mean to have proof beyond reasonable doubt? And then this starts a discussion about how you define that and what it should mean and whether you can define it in probabilistic terms or not, and so on and so on. But what Burns is saying here is what I often say in response to that kind of argument, which is that I say in England and Wales we don't have a definition, we have a process. And once the jury has decided they are sure you were guilty, that's what it is. And that's what he means here. The truth in law that is extension is definition. In other situations, there will be an almost total identity among judgments of what this is, who we are, and what is to be done. You see what he's saying here? You can't just say, what were the facts in this case? His claim is that in a deep sense, the answer to the question, what were the facts in this case, is partly, what are we going to do now? And, crucially, who are we? And this is the thought that in rendering a criminal verdict in a jurisdiction like the United States, and this is true to a certain extent in England and Wales as well, not in exactly the same way, but to some extent, the jury defines us as a political community by its decision making. It's an act of political constitution and reconstitution. It's politics in the fullest, and this is where the Aristotelian idea comes in the fullest Aristotelian constitutive sense, that the jury decides in accordance with the best of its own character. I told you it was a little bit mystical, right? We cannot, in many important circumstances, ask whether the trial has accurately portrayed reality, since the truth about the reality it portrays is invisible, save in this life. Only the jury can tell you the truth. And so it goes on. Much can be said about Bob Burns' theory of the trial. He's not entirely on his own, because there are plenty of other scholars, and some of you know, in the US who are interested in this kind of Republican communitarian conception, and it goes into epistemology as well, of fact-finding and truth and the application of the law. his own theory is distinctive and idiosyncratic, and I don't necessarily want to get into the details of that. The point for present purposes is, this is the point, there are still people out there today, not just historically, who want to make claims of this kind for the success of law in this special procedural methodology way. That all being said, most of the literature is about failure. Most of the literature that discusses legal truth is about how the legal truth, for one reason or another, fails to mirror or represent or faithfully reproduce the truth. Sure, most, not all of you know work of Thomas Weigand, a prominent German proceduralist. One of the people who I first noticed using the term legal truth, so in some respects this whole presentation is Thomas's fault to a certain extent, because he provoked me to start thinking more about this. I was pretty sure that I wasn't happy with what he was saying, but I couldn't really articulate why. Anyway, so this is Thomas some years ago, right in the US. There's hardly an arrangement less likely than the criminal process to bring out the truth, he says, and interestingly he goes on to criticise not only adversarial processes in the common law world, which we're all very familiar with as on some accounts failing to be truth conducive, but he also extends that in his own account to inquisitorial or reformed or modern civilian criminal procedures as well, for their failure to follow defensible epistemic norms. And, again, Thomas is using truth in quotation marks, talking about procedural truth, is another one to add to the list. And sentences like this really caught my attention. In a party-oriented process, truth can be defined as a version of facts acceptable to all concerned. Can it? Is that right? Last couple of comments on this, under this head. It was noticeable to me in the research that I did on this how the concept of legal truth operated differently at the rhetorical level in different jurisdictions. So nearly all of the literature so far that I've been discussing has treated legal truth as the fact of the matter, something that exists and in a sense we're stuck with. People like Bob Burns think that legal truth is a great thing, but he's in a minority there. Other scholars are critical, but most of them, or analytical like Teubner, but most of them seem to think that legal truth is what law does. It's kind of pointless arguing that it shouldn't do that. That's just what it does, and you have to deal with it one way or another. In some other legal cultures and traditions, legal truth is, as we'd say in English, a bête noire. It's something to be resisted and rejected. Why? And I'm hoping that those from the civilian legal world will connect this idea. Why? Because in some jurisdictions, the notion of objective truth is still the official policy for the system. And anything that seems to be a competitor to objective truth, or as we might just say, truth, is to be rejected. Now, I emphasise that this is taking place at the level of official rhetoric. So that's the level I'm discussing now. I mean, in reality, of course, judges always operate on the basis of their subjective beliefs and perceptions because that's all they've got. At the end of the day, in that trivial sense, decision making is always subjective at the very base level. But at the rhetorical level, some of these systems use legal truth as a concept to reject and say that we don't do that here. Now, this seems to have been, and I've read a few things about this, seems to have been an important idea in Soviet jurisprudence, whilst there was such a thing. But it's not only of historical interest because some of you know I visit China regularly, and it's still the case that the official position in China is that the judge seeks objective truth. And any talk of legal truth, and interestingly, any talk of defeasible reasoning or subjective probabilities in China, is already suspicious for them. Because it goes against, well, let's say, official party ideology. The CCP, the Chinese Communist Party, official ideology is that the law seeks objective truth. If you want to deny that, you're already contradicting what is the official position. So I emphasise that this version of discourse around legal truth is not only of historical interest, but also in some jurisdictions remains part of the contemporary debate, a rejection of the idea of legal truth rather than an embracing of it, or a kind of, we don't like it but we've got to deal with it kind of attitude. And I guess really, you'll correct me on this if I'm wrong, but my guess is, my supposition is, that this debate happened in the 19th century in Western European jurisdictions. And as soon as somebody said, no, the rule is on team conviction, personal conviction, then you've already got away from some externalist notion of objective truth. You've adopted instead the personal conviction of the fact finder as the standard. We can discuss that. Okay, so that was number 4. Remember, these claims are all around the idea of legal methodology and what it produces, good or bad. The 5th meaning is something that I absolutely do endorse, which is that a proper account of criminal adjudication will understand that fact-finding is not the ultimate aim of criminal adjudication. I'm very clear on this. Justice is the ultimate aim of criminal adjudication, and fact-finding has to serve justice. Some of the people who talk about legal truth mean that claim. They mean that in adjudication, truth is not the exclusive objective, and thus must sometimes give way to competing objectives and feelings. And I think that's right. So, again, a recent paper from a US scholar, he says, he has a discussion, and then he says, this of course assumes that the goal of criminal trials is truth, the discussion that he's been having, and in many ways we've been having. And then he quotes some authorities from US cases, case talking about arriving at the truth in criminal trials, another case saying, a very famous statement actually, the basic purpose of the trial is determination of truth. These are US authorities. He then goes on to say, however, given that courts routinely exclude truth-aiding information in order to serve some other goal, like protection of the accused from coercion and involuntary confession, it may be more accurate to speak in terms of legal truth. Well, I agree with everything he says there, apart from that last phrase. It may be more accurate to speak in terms of legal truth. I would say it isn't. But the rest of it is right. Along similar lines, this is somebody who used to be a justice of the Israeli Supreme Court. Factual truth does not always coincide with legal truth. Courts have knowingly prevented themselves more than once from reaching factual truth because of legal policy. Legal policy, by the way, in English means nothing. It's a placeholder for other arguments that I haven't told you what they are yet. When in the eyes of the legal system, safeguarding certain values and interests has been preferable to, and more important than, uncovering factual truth. Now, notice what's happening in this discourse now. We're now in a position where it's accepted that the ultimate goal of the adjudication is not truth-finding, but that thought is no longer presented as apologetic or as a reason for criticism. We're now saying, yes, that's what we do. We just do trade off those values in adjudication. The final stage in the argument that I'm going to criticise is this idea that, and then we call this legal truth. It's that final step that I dispute. Now, here's a scholar, jurisprudent, whose work I very much like. but I very much don't like this article. Robert Summers, who has a long discussion of just the sorts of things that I've been interested in this talk, in this paper. So just very quickly, he talks about formal legal truth and substantive truth. He says, it might diverge in a particular case, with the court finding facts that do not represent the actual truth. At least he's not using truth anymore, so that's good. While it is for many important reasons generally desirable that this does not occur and that substantive truth and the close approximation to it generally prevail, in some cases divergence occurs by design, on purpose, not by accident. The divergence is merely the price we pay for having a complex, multi-purpose system in which actual truth and what legally follows from it comprise but one value among a variety of important values competing for legal realisation. I agree with that, I think that's right. However, then I think he goes off the rails. Now this is a fascinating... I think he must have written this towards the end of his life, and I'm not even sure whether these are typos. Honestly, I can't make my mind up whether this is just a typographical error in the script or whether he really means to say it. But let me say it. It says, the more there is at stake, criminal blame, for example, or punitive damages, the higher standard of proof, balance of probabilities. Thus, depending on the relevant standard of truth, he now says, not standard of proof, standard of truth, the very same evidence would warrant a finding of truth in one type of case, but not another. This truth varies with standards of proof. Standards of proof vary with what is at stake. There are good reasons for these variations in standards of truth. Did he mean to say that? Or did he mean standards of proof? I don't know. If he meant the standard of adequate epistemic warrant for fact-finding differs according to different legal procedures, he was right, and I agree with him. If he really means standards of truth vary, I don't really understand what that means. Right, I know, Jody, I'm kind of out of time, aren't I? So let me just sum this up. So what I wanted to show was that there's a real live debate going on around the meaning of the concept of legal truth, that there are many contributors to it, that they are talking about different things a lot of the time. And it's kind of, this last section is quite short, although I've got more slides, but I just want to finish the diagnosis, really, because my thesis is that legal truth as a concept is never needed for any good purpose. But it is simultaneously confusing and misleading and sometimes strewn with error. In other words, the concept legal truth is always and everywhere a bad concept. Even though the debates it's applied to are very interesting debates and we can learn a lot from them. So, the concept of truth is simple. And there is only one, and it's basically Aristotle's. Truth is to say of what is that it is, and of what is not that it is not. That is what the concept of truth is. There are no others, there are no other good ones. Now, the problem is, I should say, the slides, I'm rushing a bit now. The slides go on to say, my contention is that in English criminal jurisprudence and in common law jurisprudence more generally, at least viewed in a historical way, no other concept of truth operates. All this talk about legal truth is what commentators talk about. It's not what judges talk about. It's not what's actually in the law. There is, by the way, no formal recognition of the concept of legal truth anywhere in English law, to the very best of my knowledge. It's never mentioned ever. So this is very much a commentator's concept. It's not an actual primary jurisprudential concept. And if you go back to earlier theorisations, here's James Fitzjames Stephen, writing in the 19th century, very influential evidence lawyer, as I'm sure you all know. adopting a typically Millian British empiricist epistemology, saying that problem of evidence is basically just the problem of inference. There's no. So finding the truth in law is the same as finding the truth anywhere, in principle. And you can see Thayer saying this in the US, you can see Wigmore saying it. You can see judges in deciding cases talk, when judges talk about truth, this is a quite well-known case on legal privilege in England and Wales, when judges ever talk about truth, they don't mean truth, they just mean the truth. Plain and simple, the Aristotelian one. And there's more examples. So here's what I think the problem is. I think people are confusing the claim about the concept of truth, which is, remember, is where we began, talking about different concepts of truth. I think they're confusing that claim with claims about fact-finding and the ascertainment of particular truths, or as we might more straightforwardly call them, facts. So what the debate really is about, it seems to me, is not the concept of truth, but about the proof of facts. And by facts, we mean actual facts, not pretend facts or Kellyanne Conway alternative facts. We mean actual facts. Okay? The law is very simple and straightforward on this, and I will stop in a moment. The real problem now is that fact-finding in law really is truly complex, because there are different kinds of facts. And the standards of warrantability for their assertion vary enormously. For example, and I'm going to say this and we can discuss it, for example, there are moral facts as well as empirical facts. And moral facts have to be proved in different ways to empirical facts. For example, whether the accused was criminally responsible is always in part a moral fact, one way or the other. So lots of confusion arises about proof of facts, but it's got nothing to do with the concept of truth. You know, and this went back to my earlier thing with the novels. You know, we often talk about René Descartes when we talk about epistemology, but here's a different René, also talking about epistemology. Because is it a pipe or isn't it a pipe? Well, it's true that it's a pipe, and it's true that it's not a pipe. So that's one example. Talk about mystery man, don't need to talk about that. Facts are complex in law. Lots of mistakes are made about fact-finding because people don't understand the nature of facts. It's nothing to do with the nature of truth. I've given lots of examples of this, doesn't matter. But here's the key things that we need to keep an eye on. Errors occur in adjudication. It's a human process, it's fallible, we make mistakes. We have procedural mechanisms that are both meant to preempt mistakes and correct them when they're found. And we do correct them when we can, but the fact of the matter is not all errors can be corrected for one reason or another. Criminal verdicts, I say, express asymmetric truths in the sense that we never say that the accused is innocent, we only ever say whether they're guilty or not. That's all we ever say in criminal adjudication, and we have to be very careful about that. People want to talk about the fact of innocence, but that's more complicated. And guilty is a normative legal status. The relationship to truth there is actually dispensable. In law, you are guilty until the law says you're not. That's Taubman's point. If you have a concept, like legal truth, that has many different meanings and is applied in different ways, and therefore confuses people, and if that concept also leads people into serious errors of the epistemological and conceptual and normative kind, like the sceptical epistemologist under my number 3, and if you just don't need that concept because it plays, on my account, no useful analytical, conceptual or jurisprudential role in any legal system that I know about, ergo, then don't use it.